could have been WoW. This is what WoW should have been, man.
Hey, it's Cody. Project Ascension is still online. As of July 16th, its own website says tens of thousands of active players, and its status page shows the login server in 4 realms online. Blizzard has sued the people and companies it believes are behind the project. The current public docket does not show a shutdown order, an answer, a motion to dismiss, or a ruling that Blizzard has proved its case. So today, I want to answer the question people asked after our best case video for Blizzard. What is the best case for Project Ascension? What would its defense actually fight for if the goal is to keep the game alive, protect the people who built it, and preserve the work players came there to experience? I'm going to give Blizzard its strongest facts. I'm also going to make Blizzard prove every link between those facts, the legal claims, the people it sued, the money it wants, and the shutdown it may eventually request. This is independent public record commentary, and I speak only for myself. I do not represent Project Ascension, Blizzard, Derek Powell, or any defendant. This is not legal advice, and Blizzard's complaint contains allegations rather than findings.
These guys are good. If they just shut them down, I feel like this is such a waste of good potential. These guys are cooking, man. They're cooking. Imagine they had a real team and a real company to back them up. I feel like they could go even harder.
Our technical work is independent research rather than a court ruling, with conclusions limited to the systems and dates that we examined. One legal correction before we begin. This is a civil case. Blizzard generally does not need proof beyond a reasonable doubt. The normal civil standard is more likely than not. Blizzard still has to prove every required part of every claim against every person it wants to hold liable. The burden is lower than a criminal prosecution, but a popular project name is still not a substitute for evidence. Here is Ascension's best case in 1 minute. First, avoid an emergency shutdown and use the current procedural runway. Second, narrow the civil RICO claims and separate the core operators from developers, artists, support workers, and businesses with different roles. Third, require an authenticated component-by-component comparison of Blizzard's protected work in every accused Ascension release. Fourth, prove who controlled the launcher, servers, domains, money, and decisions at the relevant time. Fifth, separate Ascension's original work and the value it created from Blizzard's material. Sixth, make damages reflect why players actually came and what actually produced revenue. Seventh, negotiate a license or authorized transition that protects Warcraft, the players, and the people who spent years building Ascension. If Blizzard will not authorize any Warcraft-dependent operation, the durable fallback is a truly independent game with its own code, world, art, names, lore, music, infrastructure, and ultimately, brand.
Bro, imagine Blizzard had a server where you could go into that section and you could just play in creator maps. Just imagine the infinite content. Like, why would anyone stop paying $15 a month? I've asked them for this so many times in the interviews. They kept saying no.
It starts with World of Warcraft under the hood and treats popularity as evidence of value rather than a copyright license. It admits the facts that hurt, contests what remains unproved, and turns the community's work into leverage for a lawful future. We tested one of the biggest factual questions in this case. When a brand new player installs Ascension, do they have to bring their own copy of World of Warcraft? Or does Ascension's official workflow deliver the client? We used a fresh Windows environment with no existing WoW installation. We signed into the official Ascension launcher, selected the included client base, and let the workflow complete. The clean game client set contained 205 files, totaling just under 42 gigabytes. The identical group included all 3 executables and 60 MPQ archives totaling about 36.92 gigabytes. The main executable was named Ascension.exe, but its embedded metadata said Blizzard Entertainment, World of Warcraft, Retail, version 3.3.5.12340, an original file name, wow.exe. That is powerful evidence for Blizzard's current client delivery theory. It makes a broad public claim that players must supply their own WoW client very difficult to defend for the workflow we captured. So, Ascension's defense gains credibility by admitting this now. World of Warcraft is under the hood. Blizzard owns its protected code, art, music, characters, world, and audiovisual expression. If Blizzard authenticates matching works, proves protected copying and distribution, and connects those acts to the defendants, the core copyright case could be strong. That is the point where some people stop thinking. The legal case does not stop there. Our reference set contains 2 Ascension captures. A court-level comparison still needs authenticated Blizzard production files or copyright deposits, a map from those works to the accused components, the relevant historical releases, and evidence showing who created, approved, uploaded, controlled, or profited from each component at each relevant time. The capture showed delivery through the launcher's playstate. Blizzard's DMCA theory still needs an exact technological measure, the work that measure protects, the accused circumvention, act or device, and the person ultimately responsible. Consumer confusion. The criminal willfulness element alleged through the civil RICO, revenue attribution, and the proper remedy each require their own evidence. The defense should demand precision because each legal theory asks a different question. Which Blizzard work? Which Ascension version? Which file? Which protected element? Which technical control? Which defendant? Which act? Which date? Which account? Which payment? Which injury? If Blizzard has that chain, it should present it. If one link is missing, the court should not fill it with the word Ascension. Blizzard sued individuals and companies with alleged roles, ranging from management and development to support and payments. Those roles do not carry the same facts or the same exposure. The defense should build a separate map for every person and entity. That map should show what they did, when they did it, what they knew, what they controlled, whether they could approve or stop the conduct, what money they received, what connection they had to California, and what injury Blizzard says they caused. A principal who controlled releases, infrastructure, and revenue can face a very different case from an artist who created original effects, a developer assigned to an original class system, a support worker answering ordinary tickets, or a business that handled a limited payment function. The law can reach people who authorized, directed, or participated in infringement. It still requires proof of what the particular person actually did. This is where civil RICO becomes Ascension's best major narrowing target. Blizzard did not limit the complaint to ordinary copyright, DMCA, contract, and trademark claims. It alleged a racketeering enterprise and conspiracy, which can create treble damage pressure and put a criminal tone around a civil lawsuit. For that theory, Blizzard needs more than a dramatic description of teamwork. It needs qualifying predicate acts, the required willfulness, or knowledge, operation, or management, where the statute demands it, an agreement for conspiracy, and a direct injury caused by the alleged RICO violation. A developer working on a lawful or original feature needs an agreement-based analysis before being treated as a part of a criminal copyright conspiracy. A support role needs evidence of direction before it becomes enterprise management. The criminal counterfeit mark predicate has a narrower definition than ordinary trademark confusion. The alleged principals face a harder fight because Blizzard describes them as decision makers. Peripheral defendants may have stronger exits. Now, if RICO is narrowed or dismissed, the ordinary IP claims can continue. That would still reduce stigma, treble damage, leverage, and the danger of treating an entire team as one criminalized unit. As of July 16th, the public docket mirror is current through document 32. 4 represented parties waived service and their responses are listed as due September 8th. Online management partners opposed Blizzard's request for early discovery. Now, after defense counsel appeared, Blizzard withdrew that request on July 10th. The latest filing is a procedural order allowing another defense lawyer to appear for Derek Powell. That withdrawal gives the defense breathing room. Its effect is procedural. The early request is gone, while the merits remain undecided if the case proceeds into ordinary discovery. Blizzard can seek records through the normal process. It can also make a new request if the rules and a future record support it. The time still has value. Ascension's side can preserve evidence, address conflicts between these defendants, prepare the first response, build a technical comparison protocol, organize accounting, document original work, and prepare for an injunction request before one arrives.
Oh my god, Templar! Oh my god!
Delay becomes a defense asset only when it is used to build proof and negotiate. Delay by itself does not create permission to operate. People keep asking whether the game can survive if Blizzard cannot find the server or identify the people behind it. The answer needs a bit more precision. Our clean capture research identified 13 coordinated patch origins under an Ascension branded domain. In the tested snapshot, those origins resolve to OVH space. That is provider level information about the patch infrastructure we observed. Customer identity, payment, account control, back-end operation, and live realm endpoints remain separate attribution questions. Blizzard's public Aeza allegation also remains incomplete on the public record. Blizzard alleged an association with the sanctioned Aeza group, that's Aeza group, on information and belief. Its early discovery declaration said Cloudflare held origin information that could help determine the actual hosting providers. In our tested set, 35 current candidates and route history for 18 preserved address candidates produced no Aeza network or holder match. Most of the historical origins we observed mapped to OVH. That result helps the defense ask exact questions: which Aeza entity, which provider, which date, which account, which payment, which defendant, and what United States connection are we even talking about? The tested set leaves resellers, customers, payers, unobserved servers, and historical relationships unresolved. Routing data identifies network paths rather than the person who paid a bill or controlled an account. Blizzard may obtain non-public records through lawful discovery. If Blizzard cannot identify an actor, connect that actor to the accused conduct, establish jurisdiction, and obtain relief that reaches the operation, the service can remain online as a practical matter. That is failed or delayed enforcement. It is not a court granting a license. So an exact physical server location is also not always required to hold a person liable. Account records, repository access, payment control, release approvals, messages, and domain records can prove conduct without a map pin on a machine. The defense wins this point through missing legal links, not through a slogan that says the server is invisible. Now we get to the part Blizzard should care about, even if it wins every legal point.
I kind of wish Blizzard would hire these guys, or at least talk to them. I don't want this talent to go to waste.
Owning a world and taking care of a world are different jobs. Ownership answers who holds the rights. The other question is what you do with something people have spent years living in. Ascension built a designed product experience that people distinctly wanted. Its official pages describe a classless progression system, where choosing abilities and talents becomes the game. They describe challenge modes, custom encounters, altered progression, community builds, new effects, new writing, and in an independent team shipping regular updates. Conquest of Azeroth claims 21 original in-house classes. Its feature material advertises more than 1,000 new spells and talents across 69 specializations. Those statements do not prove ownership by themselves. Ascension needs repositories, dated design files, source art, writing drafts, contributor agreements, assignments, licenses, and dependency maps. Some parts may be inseparable from Warcraft. Some may be mixed or derivative. Some may be functional systems that copyright does not protect. Original code, art, music, writing, icons, effects, and sufficiently original arrangements can present different questions. The defense needs a component ledger. Label each item Blizzard, Ascension, third party, licensed, functional, mixed, or unknown. Add the author, date, source, file, ownership, record, dependency, audience value, and revenue contribution. Preserve it now. Blizzard's ownership of Warcraft does not automatically turn every new contribution into Blizzard property. Ascension's use of Warcraft also does not automatically make every contribution safe. The point is to separate the work with evidence instead of allowing either side to claim the whole pile. I want to be careful about one fear I keep hearing. I have seen no evidence that Blizzard plans to copy Ascension. General game systems and abstract mechanics usually are not owned through copyright. If anyone later copies protected Ascension code, art, music, or writing, that is a separate evidence question. The best protection today is a dated, authenticated record of who made what. Ascension currently tells the public to join tens of thousands of active heroes, and it lists 4 realms as online. That is Ascension's own claim, not an audited concurrent player count. Still, this is plainly more than a small private experiment. Then, look at Savix's reaction to the Conquest of Azeroth trailer. In our July 16th snapshot, that video had about 180,000 views, 4,300 likes, and 2,400 comments. The next 14 uploads on the same channel previously had a median of 7,000 views, 127 likes, and fewer than 20 comments. The Ascension video drew more than 25 times the median views, 34 times the median likes, and 123 times the median comments. One channel does not prove why every viewer ended up clicking. The title, thumbnail, recommendation traffic, controversy, and timing can all affect the numbers. It is still an exceptional demand signal from an audience that already sees plenty of ordinary WoW content. That signal has legal and business value. It can help test why people arrived, whether Ascension's original features drove revenue, whether users were actual substitutes for Blizzard subscribers, how profits should be apportioned, what harm a sudden shutdown would create, and what a licensed relationship might be worth. Some players may subscribe to both. Some may have left Blizzard years ago. Some may be there specifically for the classless builds or conquest. Some would move to another private server or another game before returning to official World of Warcraft. Blizzard should not be allowed to assume that every Ascension user equals one lost subscription, or that every dollar came entirely from copied expression. Those are factual questions. Community love does not erase infringement. it can show the court and Microsoft what people valued, which creative labor should be preserved, and why a blunt shutdown may waste more than it protects. The private server ecosystem changes the practical answer. Blizzard obtained a consent judgment against the company behind TurtleWow that bars that company and legally covered people from operating or helping a successor. That is a binding result against the people and entity it reaches. It did not erase every circulating file, every developer's knowledge, or the audience's demand. OctoWow then appeared.
Built on TurtleWow's 1.17.2 patch, we aim to restore content through Turtle's 1.18.1 patch. Yeah, so this is basically TurtleWow.
OctoWow publicly says its work began from forked or leaked Turtle material and describes a structure designed to survive legal pressure. I have not independently verified those claims, and I'm not endorsing evasion, hidden money, or violation of a court order. The public appearance of a replacement is the relevant fact. Several directories openly advertise private WoW servers. One current directory exposes positions through 250, and other sites list additional projects. Some listings are duplicates, dead servers, or multiple realms from the same operator. Now, the claim we can support is hundreds of publicly advertised listings with the unique active total still unknown. This creates two meanings of survival. Lawful survival means a judgment, dismissal, limited order, settlement, license, or transition agreement permits some version of Ascension to ultimately continue. That gives the developers, players, accounts, revenue, and original work an actual legal foundation. Practical survival means the current service remains reachable because Blizzard has not completed the chain of attribution and enforcement, or a later independent group creates a replacement. It may keep an experience available. It does not give the current team ownership, security, or protection from the next lawsuit. An injunction can shut down a visible organization, freeze its official community, interrupt revenue, affect domains and accounts, and bind qualifying people who act in concert with the defendants. A genuinely independent later operator is a new proof problem. If evidence shows it is controlled by, directed by, or working with bound defendants, the existing order may reach it. Otherwise, Blizzard may need another legal route. So yes, the experience can return. That does not mean nothing was lost. The centralized team can be scattered, player accounts, balances, support, security, and years of coordinated development can disappear. Replacements may become more anonymous, less accountable, and harder to negotiate with. Blizzard can win a shutdown and still make the larger ecosystem worse. I understand Blizzard's calculation. Sure, a copyright owner has every reason to preserve control over Warcraft, protect official and licensed markets, prevent commercial private servers from becoming normal, and make an example of a large visible operator. A successful monetized project can create more claimed harm and more deterrence value than a tiny hobby server. The problem is what happens after deterrence stops working. If a shutdown sends players to another server, if code and knowledge keep circulating, and if future teams become harder to identify, Blizzard incurs another legal bill, another angry community, and another target. It protects its rights in one case, while the market signal reappears somewhere else. That is why lawful ownership and corporate stewardship are separate questions. A court is there to decide legal claims. Players are allowed to ask why an unofficial team seemed more willing to experiment with the old world than the company that owns it. Microsoft and Blizzard are allowed to answer with something more intelligent than an endless line of shutdowns. The best complete result is a written agreement with Blizzard and Microsoft. The defense should ask for a standstill while technical diligence happens. It should also seek dismissal of the civil RICO counts, releases for peripheral defendants, a neutral process to classify Blizzard material and Ascension original work, manageable money based on verified accounting, and an injunction limited to proven rights and conduct. For current operation, the ambitious ask is a licensed fan server or Classic Plus partner program. Blizzard could approve specific builds and realms, require audits, set brand and security rules, limit monetization, receive a royalty, protect player data, and create a cure process for violations. Ascension would receive legal continuity, credit, and a path to monetize work it can prove it owns. If Blizzard will not license the current service, the next request is an authorized transition. Define how long it runs, which builds are permitted, whether new sales stop, how players are notified, how balances and refunds are handled, and whether people can choose to migrate into a lawful new product. Every continued act during that period needs written authority. If Blizzard refuses both, the settlement should still protect original work, general skills, lawful tools, evidence copies, employment, player privacy, and the right to build an independent game. Any successor would need its own client, code, world, names, lore, maps, art, audio, interface, controls, infrastructure, and brand. It cannot move Blizzard files into a new entity and call the result independent. This is where Ascension's community becomes business leverage. A licensed, audited service keeps players in a visible environment with real accountability. A transition protects recent purchases and private data. An independent successor converts years of design knowledge into something lawful. All three options give Blizzard more control than pushing the same demand towards smaller, hidden replacements. Blizzard's response is direct. The current official Ascension workflow delivered a large client to a clean machine and reached the launcher's play state. So the executable carried Blizzard and World of Warcraft identity. Tens of gigabytes of archives came with it. Ascension publicly promoted custom Warcraft experiences, used familiar branding, operated for years, and monetized the service. Blizzard alleges notice and deliberate continuation. If Blizzard authenticates the protected files, connects the delivery and money to the core defendants, and proves its DMCA, contract, trademark, and RICO, a judge may see ongoing operation as continuing harm. The judge may also view many of the details Ascension demands as questions for discovery instead of reasons to dismiss the complaint entirely. Copying turns on protected expression and conduct. Original additions affect ownership, apportionment, and remedies while leaving any proven copying to be addressed. The existence of hundreds of other servers shows a persistent market rather than permission. A large community can increase Blizzard's claimed harm as easily as it increases settlement value. That is a serious answer. Ascension's defense still has a serious reply. Copyright enforcement has defined boundaries. Blizzard has to establish the protected work, the accused act, the responsible person, the required intent or knowledge when a claim calls for it, the injury, the money, and the legal basis for the remedy it requests. Blizzard should receive protection for what it proves. Ascension's builders should retain work they can prove they own, and each defendant should answer only for conduct the evidence connects to that defendant. Before I close, the link to my book is at the top of the description. If you enjoy these long investigations where we test our own assumptions, preserve the evidence, and let difficult facts change the argument, buying the book directly supports the channel and helps me keep doing this work. Thank you. Here's the best case for Project Ascension. Use the September runway. Fight emergency relief with evidence. Narrow RICO. Separate every defendant. Force an authenticated comparison. Identify the exact controls and acts. Prove original work. Apportion the money. Protect players. Put a license and transition proposal in front of Microsoft and Blizzard before the court decides the future by default. If Blizzard cannot complete the chain from actor to conduct to jurisdiction to enforceable relief, Ascension can survive for a time as a practical matter. That survival is fragile. If Blizzard proves the core case, a court can shut down the current Warcraft-dependent operation. The experience can still reappear through a successor, just as replacement behavior has already appeared elsewhere. That kind of return does not restore the original team, the player protections, the legal revenue, or the years lost to another fight. The best outcome preserves more than access to a server. It preserves the builders, the original work, the community, and the design vision in a form that can keep growing without waiting for the next domain seizure or lawsuit. Blizzard gets to protect Warcraft. It should prove the claims, separate its material from Ascension's original work, hold the right people responsible for the acts the evidence actually connects to them, and give the builders a lawful path. If the only strategy is to wait until a fan project becomes successful and then crush it, the replacements will keep coming, the talent will keep moving, the demand will keep appearing somewhere else, and that can be lawful enforcement. It can also be a shitty corporate strategy. Blizzard can win against the current operation on paper. If the result is another successor, another lawsuit, another group of angry players, and another team pushed further underground, the company has not solved the problem. It has chosen to repeat it. Microsoft and Blizzard have a chance to protect the world and listen to the people living in it. License the experiment, authorize the transition, or preserve the original work and let these people build something new. Shutting down a server is one thing. Solving the reason it existed is another. Blizzard gets to allege. Blizzard still has to prove. Thank you for watching.
Wow. These guys cooked hard, man. I'm so sold. Bro, imagine Blizzard had a server where you could go into that section and you could just play in creator maps. Just imagine the infinite content. Like, why would anyone stop paying $15 a month? Like, everyone will pay to play in there. This will be like heaven for WoW senior citizens. Like, Blizzard, you will have a guaranteed paycheck from us. I've asked them for this so many times in the interviews. They kept saying, no, I don't want this talent to go to waste. I actually think this is super cool. If Blizzard just evaporates them, I feel like there's such a waste of talent. If I was the company, I would talk to these guys. I think they have something to bring to the WoW community. They really